Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call that we hold every other Thursday. Everyone is, of course, welcome to join. You've heard the disclaimers when you logged in, and you understand this does not establish an attorney-client relationship. And we do the best we can with the information we have. This is not as good as having a one-on-one consultation, but we'll give it the best shot. I'm going to begin with the frequently asked questions. There are certain questions that I've listed as frequently asked, so I have accordingly marked them. I'll begin with discussion of those questions first. This is a very frequently agitated topic. What is the effect of an I-140 revocation on priority date, H-1B extensions through any employer, etc.? So beginning January 17th, 2017, the law is that if your I-140 has been approved and stays approved for 180 days and at least 1 or 2 days past January 17th, 2017, because if it was revoked after 180 days but before January 17th, 2017, when the new regulations came in, you would have to look at other things, but not those regulations. These new regulations say, first of all, the moment your I-140 is approved, your priority date is yours to keep. You can take it to any employer. You have to start the green card all over again, but you carry the priority date forward. The second thing it says is that if in addition your I-140 stays approved for 180 days, you will retain the ability to extend your H-1 beyond 3 years any number of times as long as the priority dates are not current with any employer for any job. Okay, so once I-140 is approved and stays approved 180 days, your rights to extend H-1 beyond 6 years with any employer are quite secure. That said, there was actually a mixture of 2 or 3 sets of questions here. I'll try to get to all of them as quickly as I can. So I have my I-1, this is Ashok Kumar Balasubramaniam. I have my I-140 approved in 2015 beyond 180 days now with employer A. So as long as it went past January 17th, 2017 and it stayed approved for 180 days, you are protected by the new regulations. If I move to employer B and A revokes my I-140, can I keep getting my H-1B extensions even if the second employer doesn't file a green card? Yes. Can I get multiple extensions with employer A approved I-140? Yes. There is somewhere in the back of my mind some law that says, at least it was in the proposed regulations about at least trying to file a green card within a certain, it wasn't time bound. And I have not seen it as far as I remember in the final regulations. It should be confirmed, but I'm pretty sure under the new regulations as they were passed, there is no requirement that to get H-1B extensions, the new employer must file a green card. Of that, I'm pretty sure. Okay. What if B doesn't file a green card for 2 or 3 years or more? I think that's okay. Is it possible to join an employer C with the A I-140 approved and it was later revoked? Sure. There's no limit to, it is not a number bound extension. So if you've got your I-140 approved and it stayed approved for 180 days, you can join employer B. He doesn't file a green card or she doesn't file a green card. That's fine. You can go on to employer C and keep getting extensions based upon the old revoked I-140. Revocation after 180 days does not take away your rights. Okay. You can keep jumping companies to D, E, F, G, H, all you like. And the jobs can be in totally different fields. You could go from being a software engineer to a database administrator or become a CEO of a company with no relationship with technology. So there is no requirement that the jobs must be in the same field for you to keep getting extensions. Once the priority date becomes current, you will not get H1B extensions. I believe you'll be still entitled to the 1-year extension based upon the labor certification, but you would not be entitled to, I don't think the law is very clear about that, but my guess would be you would still be able to get 1-year extension. This is my guess, guys. I haven't researched this issue and reviewed the law with this in mind. But once the priority date becomes current, you can't get 3-year extensions on the I-140, but you might still be able to get 1-year extension. And if one of them gets rejected, if an H-1B gets rejected, does it have any impact on future extensions? The answer is no. Next question was from Manasa, who got I-140 approved with employer October 2014. Priority date is August 2013. 5 years are over. Changed to H4 status in October. Employer said they will withdraw the I-140 because I'm not in their payroll. Does it affect my H1 extension? Well, first of all, the extension, because of your I-140 approval, it stayed approved past January 17th, over 180 days. You have no problem getting H1B extensions based upon the I-140. If I get a project in next month, will I get extension for 1 year? No, you'll get extension for 3 years. Nirav had another question, and also in the same, because they were all kind of in the same neighborhood, so I put all of them together. So he says, I've got a bachelor's in chemical engineering, master's in environmental technology. Oh, Nirav, I had to delete your posting because you attached your I-140 revocation with it, and that's a personal document. You should not put that on online like that. So I removed that, but I did look at the notice real quickly. You got a notice of intent to revoke. Is there any option for me to retain my priority date of the EB2 filing? Well, Nirav, I think your lawyers should look at it and they should try to argue what they can under the law. But the government's position is that they approved the I-140 in error. Okay, have your lawyer look at the regulations and see what they can do with that, because they said you were not able to prove that you had the required education, and that's a problem. Okay, guys, I have already answered all questions on this particularly frequently asked question. If you have any follow-ups on this, no new questions, any follow-ups, press *5. Okay, so I've got one from Illinois. Oh, by the way, if you press *5 twice, your hand goes down. So don't press it twice. Press *5. Okay, yeah, I see you. Illinois, go ahead, please. Illinois.
Hi, Rajiv. Good afternoon.
Good afternoon.
This is a kind of a special related to the I-140. I communicated with you through email.
Okay.
Okay. The thing is, my I-140 approved in 2010, February.
Okay.
I got my green card in 2012. This is almost more than 6 years. Recently, I saw an email from USCIS saying my I-140 withdrawal request came.
I remember your emails. I know what happened. So
Yeah.
what I told you was to contact your congressman's office. It looks like an error.
Okay.
Look, once your green card is approved, and it has been approved for quite a long time now, and then somebody says, I'm withdrawing your I-140, it doesn't mean anything. That green card is already
Okay,
granted.
that's what. Is there any impact on the green?
No.
Is there any validity of I-140 after getting the green card?
Absolutely not. And that's why I said I think this is a mistake. So once the green card is approved, it has been approved for years. Now the employer is revoking the I-140. They can do what they want. It doesn't affect your green card. Now, if there is some kind of a fraud or an error in the I-140, that could be a problem. But remember, once your green card...
Then they should revoke it, correct?
Well, once the green card has been approved for 5 years, it cannot be revoked with just a notice. They have to take you to immigration court and prove to a judge why they want to revoke your green card. Okay. So it's not going to be that easy.
Okay.
It's not just going to be with a notice.
No, because my employer is not a small guy. He's very big. He does almost thousands of green cards every year.
Right.
That's my worry.
Right. So no, I don't think this is going to be an issue from what I can see. Okay.
Okay, that's great. Thank you, sir.
Oh, you're welcome.
I'll update you after getting
do that. Okay. Sure. Good luck.
Thank you.
All right. Bye-bye. Okay, I have somebody from a voice over IP. Go ahead. I can hear you. Go ahead, please. Go ahead. I can hear
you. Rajiv.
Yes, sir.
Yeah, Rajiv. So I just want a question, like follow-up question for this. Like even the 485 been filed, is there any way USCIS can revoke the 140 I-140 based on the education? Is not matching kind of thing?
You see, the problem is this. This is actually a more complicated case than anybody can kind of predict. It isn't something that is as plain as black and white. It is more complicated and nuanced. What the government will claim is when something has been approved in error, it carries no legal meaning. So the example I can give you is if IRS sends you a check for $1 million as a refund and it's a mistake, you cannot spend that money. They're going to come back for that money. By the same token, if the government approves one of your cases and they've approved it in error, they will hold the position that an erroneously approved case carries no legal consequence. But if I were the lawyer, I would have a few things to say about that. So it's not a clear-cut case. What I would suggest is have your lawyers look into the law and see what they can argue. I don't think it's something as simple as, oh yeah, it can be denied, and oh yeah, it cannot be denied. Okay?
Yeah, so there is no time bound in that case.
No, the government is not time bound. They're not time bound. It just becomes a difficult case if it is taken in court. It becomes difficult for the government to justify their position after years and years of approval. There was a case in, if I remember, I think it was a couple of years ago, when an I-140 had been approved. This was a case in Seattle federal courts, and maybe your lawyers can look it up. And the court was very concerned that government wanted to revoke the I-140 10 years after approval. So the judge had some strong observations. My bottom line comment is that it's not as clear as an open and shut case. Don't give up on it. Fight it through. Okay?
Okay. Thank you.
Good luck. Okay, we have two more hands. One is from area code 443. Yes, area code 443. Oops. Sorry, I think I disconnected.
Hi, Rajiv. This is Manasa.
Yes, ma'am. How are you?
I'm good. Thank you. How are you? Actually, I said like my employer is withdrawing my I-140 because I'm not there in payroll, right?
Right.
What happens if they hold my I-140 even if I am not there in on the payroll? Does it affect the company?
No. See, there's a difference between holding an H-1B of a departed employee and holding an I-140 of a departed employee. There is no law that requires them to withdraw the I-140. There's a law that requires them to withdraw the H-1B of a terminated employee, but not so for an I-140. If they want to hold, they can. The only thing it affects is their ability to pay wages for future employees. But if they have a good, healthy tax returns, a set of tax returns, I don't think that should be a problem. So there's no law that mandates that they must revoke or withdraw the I-140. Okay?
They said like it's affecting their company for their future
Right.
employees
Right.
I-140
Yeah,
approval.
it can, because it affects their ability to pay wages. Then they have no choice but to revoke the I-140.
Okay.
But
Okay.
it
Thank
doesn't
you.
affect your green card. It doesn't affect your priority date. It doesn't affect your H-1B. Why should you worry?
Again, I need to process the entire thing, right? Starting
Well,
from
that
the.
that
I
you
mean,
would
if
that you would
that,
have to even otherwise, because if they
yeah.
if they keep the I-140 in play and your priority date becomes current, you can't file a 485 through a company you have left unless they are willing to hire you back.
Okay. If we get like an RFE or something, if employer B is filing the green card at labor, if we get an RFE or something, I mean, it gets rejected or something. Is there any possibility that my entire priority date will be gone?
No. As long as there is no fraud, only time you could get into trouble is if you commit any fraud. So, as long as your paperwork is clean, I don't see any problem, even if there's a denial through employer B or C or D or E or all of them.
Oh, okay. Still, I can use the employer A
Yes, ma'am.
priority date. Yeah?
Yes, ma'am.
Okay. Okay. Thank you.
You're welcome. Okay, anybody else has a related question to this I-140 revocation rules under the new regulations? Press *5. If you have a follow-up, press *5. Okay, let's go on to the next frequently asked question. Boy, this one took a long time. Okay, let's go to the next one. Yeah, this is also something that people ask me a lot. RTG has asked this question: is there any law to provide legal stay to the parent of a US citizen child with disability? And the answer is no. You can stay on a tourist visa, but is there any special visa or green card for such situations? The answer is no. *5 if you have a follow-up question on this. Oh, there is actually another. I'll get to that. Okay, area code 440, go ahead please. Area code 440.
Yeah, hi, this is Ramona, and I'm sorry, my question was regarding I-140 and green card filing.
Okay.
So I'm working in a community college since 2007 on H1B and under EB2 category.
Right.
I'm an engineer. My priority
Ramona,
date is November 2000.
I know you have a question further down about becoming a provost, don't you?
Okay, thanks,
Yeah,
and
but
I would
that's
not
okay.
interrupt.
Since you asked me already, I can tell you this, that
Yeah,
if you become a provost, I think you're going to have a problem with your H-1B. Give me 1 second.
okay.
Let me get to your question. Just hang on. When we get to your question, we'll
Okay.
get to it. I have it. I remember your question.
Sure.
Okay.
Okay, thanks. Appreciate it.
Bye. Okay. Yeah. So going back to the frequently asked question, I answered that there's no special provision for parents of a US citizen child. We dealt with this. I think we have one or two maybe more frequently asked questions. Let's take a look at that. Yes. So this is another one. First of all, to say that USCIS has changed its regulations and they do not allow off-site placements of STEM OPT extension students, it's incorrect, because USCIS has said this from a very, very long time back. They didn't say it definitively, but they gave a very broad indication that they're not going to allow these placements. I have been telling our clients, every single one of our clients, corporate clients, has not taken any STEM students to be placed off-site, because off-site placements were against the regulations which require close supervision of the students. Now, if you are in that situation, what can happen? You could be considered to be out of status for no fault of your own. So when you file an H-1B, if the government says, well, we think you're out of status, hopefully that's all they can do. They can make you go outside USA for a visa stamping. I don't think they should visit any consequences more serious than that. That would be my guess. Okay. And it doesn't matter whether the H-1B is filed by the end client or anybody else, because the same issue can be raised about the maintenance of status. Star 5 if you have a follow-up question on this. Star 5. Press star 5 on your phone. Okay. This is the last frequently asked question and also very important. How does one change status while within the United States? This is a fairly lengthy topic. I'll try to cover it as quickly as I can. So there are 3 types of situations that I can think of. One situation is when you are changing status from one to another, which can be filed just by using form I-539. So when you convert from H1 to F1, H1 to tourist visa, all of these can be done through just a simple filing of form I-539. Then there are some where the change of status requires refiling of the entire paperwork for the petition. H1 and L1 are examples of that category. So let's say I've got my H1 approval, but in the paperwork I mentioned I don't want to get H1 approval within the USA. I'll go get visa stamping later on. They will give me the H1, but I will not have an H1 I-94 change of status. Now if I want to do a change of status within USA, I have to refile the entire H1 asking for a change of status. So it's pretty much like reopening the case. It's the same for L1. For H1s and L1s, you pretty much refile the whole case. The third situation for change of status is certain categories of people are not allowed to change status. For example, if you are here on a visa waiver, also called ESTA, excuse me, program, you can't change status, you can't extend status. Okay, so this question from Chandi K was asking me, I'm currently on L1B, I've got my H1B, now how can I switch? And of course, one is to go outside, get a visa stamping. Second is to refile the H1B with a change of status request. So visa stamping is outside and change of status will be within USA. Star 5 if you have a follow-up question. Star 5. Okay. And this looks like Washington. Go ahead. Area code 425. Yeah, go ahead.
Hi, sir. How to refile for H1B for the second
Okay.
option,
Yeah.
like change of status?
Yeah. What happens is, so you are on L1B, let's say, and your employer got an H1B approval for you without change of status. So you continued on L1B, but when you want to convert to H1B, you have to do one of the 2 things. Either you have to go outside, get an H1B visa stamping and come back, or you have to ask USCIS for a change of status from L1 to H1B. To ask for a change of status, the entire paperwork for the H1 has to be filed again. You won't be subject to the quota, but the paperwork has to be filed again. Okay. Well, actually, let me take a step back. Would you be subject to the quota? There is some doubt about that also. I'll tell you something. After stating everything, I suddenly realized that it might be a problem because there are some interpretations from the government that say until you receive a change of status. Yeah, I think you'll be okay. You'll be okay. Because here is what the government is interpreting. They're saying, we don't consider you to be quota exempt until you get change of status or H1B visa stamping. In your case, it has been deferred or delayed, not denied. So why can't you ask for a change of status now and still be exempt from the quota? And I think you can. The only problem is when you ask for a change of status, it's like refiling the whole case. They can ask for everything.
Refiling means...
But it's the same paperwork.
Refiling means...
It's the same paperwork, slightly different.
Standing in the lottery again?
No. That's what I said. You're not subject to the lottery, but it is the same form I-129. It is the same supporting documents. same proof of specialty occupation, same proof of employer-employee relationship. So you've got to pretty much do the whole paperwork all over again.
So it seems like the easier option is to just go out of the country
Yeah,
and get the
I
stamp
wouldn't be
at the
too
border.
sure about that. I have a client who's got a very strong case, multinational company, very respectable company, excellent degrees, MBA, engineering degree, stuck in Japan for months, and we are trying to push the case. So it's a very clean case. So they are trying to delay and deny as many cases as they can. So before you go, just make sure you discuss it with your lawyers and figure out what is the best way to do it. But yeah, both options are open, at least theoretically.
So going out has its side effects also. You can get stuck outside.
Absolutely.
Yeah, thanks.
Okay, good luck. Okay, now let's get started with all the other questions that were not frequently asked. Ram Kumaran says there was a labor cert approved and the completion year was entered incorrectly in PERM 2003 instead of 2002, but labor was denied for some other reason. You filed an appeal, the appeal was approved. In the meantime, another case was approved. In that case, I-140 was also approved. Then the earlier filed case, which was the one that had a typo, was approved. Should we point out this typo in the I-140? I don't see any need for it because it appears to be an insubstantial error. You should talk with your lawyers. Substantial errors are those that affect the merits of a case. Okay. So for instance, if some case requires that you not be married and we said you were not married, in fact you were, that's a material problem because if the truth was revealed, your case would be denied. So when there is a minor technical error, I don't think the government is going to make a big issue of it. Personally, I don't see any need to for us to explain that error. It's a typo. You can do it one of the two ways. You can let the government know there's a typo and just a typo, or you cannot say it's an immaterial error. It's a judgment call that the lawyers have to make. *5, any question on this? *5, press *5 on your phone. Okay. Now this is from Ramona. She's on the phone. She's working at a community college since 2007 and on H1B, EB2 category. Priority date is 2011. She was a project manager in the engineering division. Now wants to apply as an associate provost. It's a new position, an obvious promotion. Does it affect my PERM? Yes, it does. Because as I understand the job of a provost in a university is basically an administrative officer in charge of both some aspects of administration as well as the curriculum for the education. Your degree is in engineering. What relationship does it have with the job? So you might have trouble getting an H1B. Second, in order for you to continue with the green card, you'll have to refile the PERM because this is a substantially different job. So when you refile the PERM, you'll have to start from the very beginning, but you'll be able to keep the same priority date. Okay. I don't think you can take this position on your existing H1B. It's a substantially different position from what I can see. *5 if you have a follow-up question, Ramona. Okay. Ma'am, I can hear you. Go ahead, please.
Yeah, so thank you. This is well addressed. The only thing is my I-140 was also clear, I guess 3 years ago. So does that help?
No, because see, your priority date, ma'am, has become your property. You can take it anywhere. Your right to extend your H1 beyond 6 years has become your property. You can take it anywhere. But if you want to continue with the green card, you still have to refile as a provost.
Okay. All right. Thank you.
Good luck.
Thank you.
You're welcome.
Thanks.
Okay, so Mr. Reddy wants to know, I'm on H1B working for client A, applied for 10th year of H1B extension. With approved I-140, I-94 expired in Jan 2018. So extension was applied a few months earlier. Project got ended, joined new client B in March 2018 within the same MSA. Since my employer did not file for amendment, hence my employer, okay, that makes sense. I usually would if I were your employer. In the meantime, I got RFE for my H1B extension. RFE is related to specialty occupation and how BTEC in electrical is relevant. Can my employer submit the RFE reply with client B related documentation? Yeah, this is a little tricky. I don't think I can answer this question again. This is not a yes or no question. This has to be done by the lawyers. Typically in our office, we try to show the government that the first case was appropriately filed and the second case became necessary because of another move. So does my employer need to file H1B amendment and get the things in premium processing and then respond to RFE? So client B, there's a client A in the beginning, then okay. Yes, there has to be an amendment in, here is the problem, okay. The reason I said I would have filed an amendment is because even if you change location within the same area, you still have to do LCA posting in the new premises. A lot of employers don't realize that. And that's, if you don't do that, that's a violation of the H1B regulations. So I normally just file at least a new LCA for the new location, even if it is in the same neighborhood. Second, if the project changes, I think that's a substantial change in the job. It's usually a good idea to just file an amendment. Okay. Now here, it's a difficult call. I can't really make this call. Your lawyers have to. I wish I could tell you what to do. But if you were our client, we would have had you file an amendment. No question about it. *5 if you have a follow-up question. *5. Okay. From New York. Okay. Go ahead, New York. Or New Jersey, 201. Go ahead. You raised your hand. Hello. I can hear you. Okay.
Hello, sir. Are you able to hear me?
Yeah, I can hear you.
Reddy.
Yeah, go ahead, Mr. Reddy.
Sir, so the thing is, like, my employer is saying that he will not file amendment since it is within our MSA, and he is trying to, like, reply to the RFE. So, like, as you said, it's a tricky situation.
Yeah, I think
so,
not filing an amendment is a mistake, but that's my call. I don't know the case. I'm just making a judgment call from the outside.
Okay, sir. So I just a follow-up question on this, sir. Like, if there is any negative impact, say, like, if the H1 extension gets delayed, so can I transfer with the same position to some other employer since I already have I-140 approved?
You'll have to go outside USA. Yes, you can, because there is a loss of status. But yeah, you can always file another H1. I don't see any problem with that.
So that has to be done going outside the country, sir?
Yes, sir. Okay?
Okay, sir.
Good luck.
Okay, sir. Thank you. Thank you very much. Thank you.
Okay, so let's go on to the next question. Okay, we dealt with this. This was a frequently asked question. Okay, next one is, I have an approved from Kayak. I have an approved H1B petition from employer A and B. I currently work for employer A. Employer B is valid and not revoked. A is good till 2019. B is good till 2020. Petition for employer B was applied recently. I did not join them and I continue to work for old employer. I would be traveling to my home country soon and would have to go for visa stamping for employer A. Do I need to provide any information about the employer B? No, unless they ask for it. It's okay for you to have 2 valid petitions and choose to get visa stamping through the one that you're working on. I don't see any problem with that. So if you are asked any questions, please respond to them truthfully. But is this illegal? Not at all. *5 if you have any follow-up questions. *5. Okay. Oh, there is a follow-up question. Area code 571. Go ahead, please.
Yeah, hi. We are in a similar situation here. Right now, I'm working with an employer A on an H4 EAD,
Okay.
and employer B has filed my H1B for this year, and it has been picked in the lottery but not approved yet.
Okay.
So my question here is, if I want to continue working on EAD and my H1 is approved, so from October, will I automatically have to start working with employer B? But I want to stay with employer A itself.
That depends upon how the H1 was filed. If the H1 was filed requesting a change of status, the moment October 1st hits, you are on H1, not on H4. If you are on H1, naturally you cannot use your H4 or H4 EAD.
How will I know if how the H1 was filed?
You have to discuss it with your lawyers and your employers. Most likely it would have been filed as a change of status case. That's how most of these cases are filed.
Okay, so mostly, so they'll be having a I-539 in the petition?
It isn't 539, it's I-129. It has a box in there. Are you asking for a change of status or consular notification, something like that? So if it says change of status, it's just a box. I think it's on page 1 itself of the form. I haven't filled a I-129 form in 20 years, so I don't really remember what the form exact question is. But there is a question on the form. Okay.
Okay. So can I apply for another change of status from October so that I can remain on EAD?
No. Once the change of status is approved, the old status is cut off and the EAD is gone. That's the way I see the law. Although I'm hearing some of you say that no, government has said you can keep using. Further down, you'll hear some other questions on this topic. You can stay tuned and see what the other opinions are. But in my view, you can just withdraw the H1 if you don't want to go forward.
Okay. Yeah.
Good luck.
Thank you very much.
Oh, you're welcome. Okay. Okay, so this is from GK and J. In June 2010, I traveled outside on expired advance parole unknowingly. I was detained at the port of entry. I was issued a humanitarian parole for 4 days, asked to leave the country. Per your professional advice, I filed for an AP, left the country. By the way, this law has changed, or this policy has changed. Now, if you leave after filing the advance parole, the advance parole is gone. Okay, you filed an AP, left the country, filed new H1B, got stamping, came back on H1. 2 years later, my green card got approved. Since then, on each of the 3 times I came to the USA, I was kept waiting at the port of entry for additional scrutiny. But then it was okay. So question, are there any recent port of entry challenges for green card holders while returning back? I'm planning to go to India next month. I'm cautious. I applied for US citizenship 3 months ago, mentioned about the parole aspect, etc. Should I take any proactive or reactive measures? Look, here is the problem. There are a couple of extremely gray areas in your case. Okay. So first of all, the moment your advance parole expired when you were outside US, when you left USA, your I-485 is deemed to be abandoned. Okay. Then you went and got an H1B. Did that cure the problem? I don't think so. So it's a very difficult situation for the government to decide whether they approved your green card by mistake. Should they go back and revoke it, which is quite problematic. It is not easy. So I think that is part of the issue here, that it's not a clear-cut case. What you can do is you can try to submit a trip inquiry. So if you just type in your search engine CBP, which is Customs and Border Protection, space trip program, TRIP, like taking a trip, you should come to a page that allows you to submit inquiries or additional information. And that information is made a part of your record, which is visible to the port of entry officer. So when you return, they should not delay you or detain you that long. You can ask them, why am I being delayed? What is going on? What can I do to correct this situation? But it's difficult for me to give you a definitive answer because I don't know what the government is thinking. *5 if you have a follow-up question. *5. Okay. Let's go on to the next question. PBANTH0914, I've submitted the application I-539, change of status from H1 to H4. It's still pending. I have an H4 visa stamp. Can I still submit application for H4 EAD? Well, the H4 EAD is tied to the H4. Okay. With a pending H1 to H4 request, you can always add on your EAD request. I don't see why not. Now, is it faster to travel outside and get H4 visa stamp and apply for EAD? I have no data with which I can compare and give you that answer. Personally, I don't think so, but I don't know for sure. *5 if you have a follow-up question. *5. Okay. Let's go on to the next one. Guys, I want to make everyone aware I will not have time for new questions because we have the entire hour taken up with the existing questions and follow-ups. So I may not get any time at all. We have only about 15 minutes left for this call, okay? Next question is Dev 2018. I had an H4 EAD approved in 2016. Went from H4 to H1B in 2017, resigned H1B employer in 2018, came back in H4 status. I called USCIS, they said it's okay to use my previously given EAD card. You see, I don't think that is correct. Okay. But again, immigration law is infinitely complex because I don't know definitively whether it is correct or incorrect. I personally think the moment you went from H4 to H1, your H4 as well as EAD were gone. But then there are also regulations. In order to revoke the EAD, they should be sending you a notice. I don't know if that EAD is still valid. Okay. So you want to know, can I verify this information? I think, in my view, the best way to verify is to just contact your congressman's office, ask them to get you this information. Usually they can get it for you within a 1 or 2 day period. What happens is, whatever USCIS tells the congressman is likely to be a lot more reliable than any information that you get either by going personally for InfoPass or calling their customer service. By the way, do let me know what they say. It's a very interesting situation. You can email me to help@immigration.com. help@immigration.com. And by the way, we don't know what's going to happen in June when they try to revoke the EAD because I don't think they can take away the existing EADs. I don't know how they are going to proceed. I think there have to be some orderly changeover from EAD to no EAD. I don't think it'll be that easy for them. And we'll see. We'll see. It's difficult. We don't know what the program is going to look like. Okay. Upasna says, I'm in adjustment of status. Interview was done. EAD is expiring November 18th. Applied for renewal. It's over 180 days. Please advise, what should I do? Well, first of all, your EAD is expiring November 18th. Oh, I see. So even the 180-day grace period is over. I'm not sure what you can do at this point of time. You can try contacting, again, the congressman's office to ask them to expedite, because you cannot work without having a proper EAD. You should stop working and wait for the EAD decision to come. You can also contact the Ombudsman's office, but usually it is easier and perhaps more reliable to go to a congressman's office. *5 if you have a follow-up question. *5. Okay. Okay, this question is so long that I don't know what to focus on. Wait, there is Upasna. Yeah, Upasna ji, go ahead. I can hear you.
Hello, sir. So that means this 27th, this month, I will be out of status?
No, not at all. Not at all. See, as long as your 485 is pending, you can never be out of status. You just can't work.
Okay.
Okay. So you just have to.
So,
Yeah, go ahead.
stop, you mean stop working on the 27th?
Right. Whenever the 180 days are up, you have to stop working.
But I contacted the congressman office and they contacted the local office for my I-485 for my green card, and they are saying that supervisor review, so they don't have answer yet. And I tried to contact the National Service Center and they didn't give any answer. They just said that it's in the line to be reviewed.
Right. So the answer is you are not out of status. You will not be out of status. You just can't work. Okay.
I see. Thank you, sir.
You're welcome. Good luck. Okay, let's go down to, yeah, like I was saying, this is such a long fact pattern. Contact GS, are you here? Contact GS, are you here? Press *5 if you're here. I don't really know what you're asking me. What I want to know, if I can stay in the US, so I would be completing 6 years on H1B soon. What is my legal status? Would the perm go in pending status after appealing against perm denial? Do we need to file an H1B extension with the perm with the priority date of 15 June 2017? As the older perm is already withdrawn. Don't know what you're asking me, sir. This fact pattern is so damn complicated. Don't know where to begin. H1B got approved for 2 years. I'm sorry, I'm not going to be able to deal. I just don't have enough time to go over these facts. If you were on the phone, I could have talked to you. Next question, G. Rivas. 3 I-130 related questions. So yeah, CSPA allows you to deduct from your age the time during which the I-130 was pending. Okay. So if it was pending 5 years, then you can only deduct 5 years from your age and you're still 24 years old. So you're not covered by CSPA as far as I can see. Because you said visa has been filed in 2004, approved 2009. But we did not get the notice to contact USCIS. I'm not sure how you are covered by the CSPA under the facts of this case. Because I don't think you have, again, I could be wrong, I don't think you have any specific special protection if they fail to notify you. CSPA doesn't change that. And again, for derivative beneficiaries, I don't think you can become a green card holder unless your parent, the principal, becomes a green card holder. I don't think you can do it independently. And marriage is marriage. It doesn't have to be civil or registered. As long as it is legal in the country in which it was performed, that marriage is a marriage. It doesn't have to be any specific format. If it is legal in your country, it is legal. *5 if you have a follow-up question. *5. Okay. Deep Impact says, I was on L1A, applied for H4 change of status in EAD on December 1st. Try to expedite. It's been pending more than 100 days. So I thought of going for H4 stamping to Canada and reapply for H4 EAD. So you got an EAD approval, a notice, but not the H4. So what do I do now? Well, I don't know what that means. Normally, they shouldn't approve an EAD until the H4 is approved. Are they making any special exceptions because the times are so long? I'm not aware of any such procedure, but I don't know. I don't know what to tell you. Normally, the change of status and the EAD should be either at the same time or change of status first and EAD follows. What will happen to my EAD if I go to Canada? Don't know. I have no idea what's going on. So again, congressmen or ombudsmen are the good choices that you can go to. Figure out what's happening. Of course, contacting USCIS is a possibility. I have a 10 days of grace period. Can I use my remaining paid vacation for 10 days? Or do I need to apply for... the grace period doesn't require you to work. I am an India employee from my company. If I can't apply US paid leave, can I apply India leave? Now, see, the thing is that 10 day doesn't require you to have any particular status or job in the USA. It's given to you automatically. Okay. *5 if you have a follow-up question. Go ahead, area code 972. Go ahead, please.
Hi Rajiv, Deep here. So, like, what do I need to do for that 10 days? Do I need to, how do I take care of the time sheet of my company?
Okay, first of all, you said you're currently still working on L1, right?
No, yeah, like I was on L1, but 30th April, my L1 got over, my project got over. I will be traveling to India next month because right now my H4 COS is pending.
But if your change of status is pending, you cannot be out of status. So even if you stop working, because your COS is pending, you can just stay in USA.
Yeah. So only question is I am still the employee of the company, though I am not working here after 30th April because that was my last day.
As long as you don't get paid, I don't see any problem with being on their payroll.
Okay. So I can't. I need to apply for leave without pay or something, or I need to take the India transfer. What is
that doesn't really matter as long as you're not. Look, unauthorized employment means you are working and getting paid or getting any benefits. But if you're not working and still getting paid or still getting benefits, that's fine.
Oh yeah, because I have some leave and my I checked with my company HR.
You can do that. You can take.
So I can apply that leave, right?
Yes, of course.
Yeah.
Because you're not working, you're getting paid the amount that you have already earned. Because the leave that you earned is a part of your job that you already done.
Right.
So no problem. I don't see any issue.
Okay. Well, the only confusion I was because they written in the notice you are not authorized to work. You have 10 days grace period and regarding
you see, you're sitting at home and getting paid for money that you already earned.
Okay, so that should not be a problem, right?
I don't see any issue with that.
Okay. Thank you so much.
You're welcome, sir. Good luck. US New Jersey says, does having a recent one foreign employment and one foreign address for about 10 to 11 months have any negative impact on N400? Sure. They can, no stay outside was more than 6 months. They can still ask you to explain what happened. But if you just took a temporary job, see, I don't know all the facts. If you just took a temporary employment, did not leave your permanent residence here, your family continued to stay here, I don't see any problem. But I think it's better for you to do a quick consultation with a lawyer. If you're on the phone, press *5. Okay, let me just get your facts. Let's talk to you for a second. Okay, so you took a job.
Hi, Rajiv.
You took a job outside USA. Is that what happened?
Yes, Rajiv. So actually, last year in March of 2017, I had got a position back in India.
Right.
So that's the time when I went there actually.
Are you married?
No, I'm single.
Okay. When you left USA, do you own a house or did you rent?
No, so I actually rent an apartment and I maintain the residential lease
Even when you
for my
were
apartment.
gone, you had the lease.
Yes, I had the lease. The only thing, Rajiv, is since I was staying with the landlord for many years, the agreement I had with him was that since I'll be making frequent trips, I paid the rent to him for the months I came back.
Okay.
For the months I wasn't here, I didn't pay him.
Okay.
But I still maintain the lease, though.
Why did you take a job in India instead of continuing with your job in USA?
Actually, Rajiv, that was a position, I was interviewed here, but they told me the position was in India. It was something that I wanted to do.
Okay. So it was a short-term project.
I didn't have
it was a short-term project. It wasn't a long-term job.
No.
Okay. Yeah, I think you should be fine. The only time you'll have a problem is if the project was indefinite duration or it was a long-term project and then you left. If you know you're not going to be gone more than 10, 11 months, I don't see any problem.
But the only question, Rajiv, is how do I prove that it was a short term? I mean, I know it was a short term and that's why I came back. But me, coming back, is it itself a proof within itself?
Have you taken up another job now?
Yes, so I came back to the US in January and I got a job, and since then I've been living and working here. But I applied for my N400 in December of last
I don't think it's a problem.
So I can go ahead with my N400.
Right. And you said you applied your N400 when? Did you apply it 3 months after you came to USA?
So I applied in December on one of my trips. So I was here in November and then applied in December.
That's probably not going to work because government can always raise another issue which you haven't brought up, but I see it. That issue is of domicile. Domicile means you stay in that state and you have the intention to keep on staying in that state. When you are just coming and visiting and going back again. So for that reason, I would refile the N400.
So Rajiv, I actually thought of that, but the question I had was, I mean, since I was not absent for more than 365 days, the domicile still remained as my state.
That's a different issue. Now I'm talking about domicile. That's a different issue. Because N400 requires that you must be domiciled in the state for 90 days before you apply. Okay? And domicile requires actual physical presence in the state combined with the intention to stay there indefinitely. So I think domicile could get you into trouble. I think you're going to have a problem with that.
Even though I was staying for 9 years, before I left?
Yeah,
in
that
the same
doesn't matter because the discontinuity can strike you even after 20 years. So you want to take a chance with it, you can. But I think that could become an issue. It's not a fatal issue as long as you don't lie about it. You tell the truth, whatever they ask you. If it gets approved, great. But, be absolutely upfront about any questions they ask. Maximum they can say is, no, you have a domicile issue and they can make you refile the N400. Or you can do it voluntarily. Your call.
I see. Okay. Okay, Rajiv.
Good luck.
And Rajiv, that's the last question. How long is it taking for the N400 these days? I'm seeing quite...
USCIS website is the most reliable source so far I have seen. They have the processing time for all the sub-offices.
Okay. All right, Rajiv. Thank you.
Bye-bye. Okay, so Rick wanted to know, apparently we've talked about this before. I posted this question during the last call. Yeah, we had some technical difficulty last time. Rick, are you here now? Press *5. Okay, good. Hi, good afternoon. I don't know what happened last time. We couldn't figure out what the problem was. I think I screwed something up.
Right.
Yeah, I think, you know what I did? I think I forgot to make myself a host. So what happened was, when I muted everybody, I think I muted myself too. So the recording was going on because recording is being done locally in my office through our PCs. But you guys couldn't hear me because I was on mute like everybody else. I think that's what happened. That was the only analysis I could do. And I tried to figure it out. I just made sure this time I didn't make that error. Okay, now going back to what we were talking about. You were asking me about H1B change from a non-profit to a for-profit. Okay. To find a for-profit employer who can file my H1B. Okay. That I need to go under cap again if my cap subject H1B is approved. Oh my God, I can't even understand what I said. If that's what I said, I don't even know what I mean. Okay, I don't blame you for being confused. I don't know what I'm saying. Okay, let's try it again. So you are right now on a non-profit H1B, right, Rick?
That's true.
Okay, so you have a quota exempt H1B. Did you ever have a quota H1B approval?
No.
Okay. So if you now want to work for a for-profit employer, you want to completely transfer over, you have to go through the quota, right? That much is clear?
Right.
Okay.
Yep.
Now, interestingly, for quota exempt employees, you can have a concurrent H1 for a quota employer without going through the lottery. So let's say you are working for NIH and it's a quota exempt employer, and you at the same time want to work for Georgetown Hospital. You can concurrently work for both employers on two H1s, even though one of them is quota exempt, the other one is not. Okay, although Georgetown is also quota exempt.
Right. In that case, but I have to continue working for
both
the quota exempt employer.
Yeah. Okay. So now the trickier question is when somebody is on a quota job and they go to quota exempt, that becomes a little trickier. I'm not sure what the answer is. I think they are still quota exempt. But what is your situation? What did you not understand, and what was your question?
Sure. In previous call, you commented that for example, if I find another company that could file my cap subject to H1, and for example, it got picked in the lottery and it got approved, then if I don't transfer to that company, I can still be here.
Oh yes.
And then my exempt H1 is still valid.
Oh yes, I don't have any doubt about that.
Yep, but should I have to go to the cap again?
No.
Is my question.
No. See, no. Okay, let me let me backtrack that a little bit, because I think I understand what point you're making. The point you're making is this: I'm working for a quota exempt employer. I got my H1B approved through the lottery for another employer. If I don't join the other employer, am I still exempt from the lottery? Right?
Right.
And the answer is yes, if your change of status or transfer of status was approved with an I-94. I think that would be my guess that you're still exempt from the quota. Because what exempts you from the quota is not actual joining that employer. What exempts you from the quota is the change of status / transfer or visa stamping through the exempt employer. After that, even if you don't join them, you should still be quota exempt.
Yeah, that's my question. That's the tricky part I didn't understand.
Right.
So what can you explain a little more about change or transfer of employer? Should I do anything, or should when you?
See, I explained that in a slightly
automatic.
Yeah, I explained that in a slightly different context. Several times, you might have heard me that when you file the Form I-129, there is a checkbox. There's a checkbox. Do you want to do a transfer of employer / change of status, whatever that is called, in the context of a changing employer? So what happens is you get an I-94 within the USA for that employer. Okay. So if you file it like that, then your H1 is complete. But what if you say, approve my H1, but I'll go for visa stamping outside USA? In that case, until the visa is stamped, your H1 is probably not approved. And then you are still subject to the quota. Okay. That's the difference.
Now I understand. For example, in the second case, we didn't file it that way.
Yeah, nobody does. Nobody does. I mean, that's a very, very rare case. We hardly ever do. Somebody is in USA, we always file it that I'm going to change everything locally. Why would I want to go outside?
Right. Okay. So if at all, if I find some job in next year, February,
you should be okay as far as I can tell.
Then, okay, I can use the the approved H1 already, and provided that the new employer wouldn't revoke my H1 before October 1st.
As long as not revoked before October 1st of the year you were approved for.
Okay, even if he revokes it after October 1st,
I don't
then
think
doesn't
it's
matter.
a problem.
Oh, okay. That's the question. That's the tricky part. I didn't understand.
Right. All right.
No, I think that's it now.
Good luck.
Thank you.
You're welcome.
Yep.
Okay. PK007 got admitted from US University MS starting this fall. I'm in India. I have good working experience working for a top company. Parents want me to get married before I move. Is it okay to get married before entering USA but after getting my F1 visa? And I don't like that. I just don't like that. I think it's much better. Again, maybe I'm being too finicky about this, but I would rather be that. If I were you, okay, if I have to get married, fine, then so be it. But then I would go back and ask the consulate, preferably in writing through an email, should I come in for a visa stamping again? I have gotten married to a US green card holder, okay? Or even physically go to apply for a visa. If you do that and they say, okay, well, you can keep your visa and that's okay, then you have no problem. But not revealing it to the government, I think that's problematic. *5 if you have a follow-up question. Okay, guys. Well, I don't have any more time for today. We'll talk again in 2 weeks, and hopefully we can... Oh, there's somebody from Washington. Okay, you have a follow-up question? Go ahead, please.
Yeah, so what I meant was, I didn't mean to hide it, but it's like
No, I understand that.
I want to get to the US.
Yeah, but think about how it looks. You know, the government officers are not your friends. To them, everything you do is suspicious. So if somebody gets a student visa and before they travel to USA, they get married to a US green card holder, government can raise the possibility that maybe you were lying to them, that you actually had the intention to stay in the USA permanently and you should not have gotten a student visa for that. Okay. So I'm concerned about that, and especially with this administration, I would be careful. Maybe you won't get into trouble, but I wouldn't want to take a chance with this.
Okay,
Better to be overcautious than overconfident.
So do you suggest to get married after the person comes here?
After the person
Like
comes
studies here, what is a
wait,
good time to get
they
married?
should definitely wait a few months, reassess their situation. They really do want to get married, then go for it.
Okay, cool. Thank
You're
you.
welcome. Good luck.
Thank you.
All right, guys, as usual, it's a great pleasure and privilege to talk with all of you. We'll see you again in 2 weeks. Thank you for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.